in the appeals Dane, another against Hosebay Limited, Howard the Walden Estates against Lexgorge Limited.
Lord Canvas will give judgment.
These two appeals raise the question of whether a property used wholly for commercial purposes may qualify as a house for the purposes of legislation governing the right to leasehold enfranchisement. In both cases, the buildings were originally built as houses and in some respects retain the appearance as such, but they have since been converted to use in one case as a self-catering hotel, in the other as offices. The definition in the relevant Act raises two separate but overlapping questions. One, were the buildings, quotes, designed or adapted for living in, close quotes. Two, were they houses, quotes, reasonably so called, close quotes. In the event, the decisions have turned solely on the second of those issues. The judges below in the Court of Appeal held that they were houses reasonably so called. The Supreme Court unanimously allows both appeals, holding that neither property was a house reasonably so called on the relevant date when the statutory notice was served. The Court of Appeal acknowledged that its decision was not in line with the intention of Parliament when it enacted the amendments introduced by the Commonwealth and Leasehold Reform Act 2002, but felt constrained by the statutory words. The Supreme Court disagrees. In relation to the second part of the definition, the expression house reasonably so called ties it to the primary meaning of a house as a single residence, as opposed to, for example, a hostel or block of flats. It needs to be read in the context of a statute which is about houses as places to live in, not about houses as pieces of architecture or features in a street scene. Accordingly, the external and physical appearance of a building is not to be treated as determinative, nor should the terms of the lease be treated as a major factor. The buildings in the first case were not houses reasonably so called. The fact that they might look like houses and might be referred to as houses for some purposes was not sufficient to displace the fact that their use was entirely commercial. In the other case, the building was not a house reasonably so called because it was wholly used for office purposes. The fact that it was originally designed as a house and is still described as a house for many purposes, including in architectural histories, was beside the point. Accordingly, for the appeals will be allowed and the parties will make written submissions on the precise form of the order and on costs by 31st October 2012.